Welcome to RentSmart. We are going to do Module F, which is rental agreements, moving in and moving on. So before we get started, I'm going to go over why you're here. So after your 5 classes, Module B through F, you will take a quick little assessment. As long as you show up to class, you pay attention, participate, you will do great and pass. I'm not worried about that. And then it will provide you a certificate with your name on it, and it's a way to show potential landlords or property managers that you may have low credit score or bad rental history or both, but you're growing as a tenant, you're learning, and you're improving as a human. So you'll learn something, I promise. So let's get started. A verbal agreement in Wisconsin is legal as long as it is 12 months or less. I don't recommend it. However, it is legal. You can go to court and do the whole he said, she said thing. It can get ugly, but it is legal. A security deposit can be used as your last month's rent on very special occasions, and that means if you and your landlord or property manager agree upon that, I would not go into a lease assuming that you can just leave and not pay last month's rent. I also do not recommend that either, because you should be getting a deduction sheet of where your security deposit is going, and if you use that, you probably won't. And then the last one, evictions showing up on your credit report. So it does show up on your credit report for a certain amount of time, and it also can show up on CCAP for up to, let me check my notes here, I believe it's up to 20 years. Yep, up to 20 years if it is not paid off, but if it is paid off, I think it's up to 7 years. So if you do have evictions, get those paid off. Try to make some sort of payments while you're here at Freedom House, so then it will, get expunged off your record as soon as possible. So let's go over the first page. We will be talking a lot with not legal words, but more of the legal process of an eviction. And then I do just want to remind you that the Tenant Resource Center, which is the first resource for you, and the Landlord Tenant Guide is wonderful. Utilize their website, and Legal Action of Wisconsin is a free to low cost legal aid here in Wisconsin that can help you go beyond just landlord-tenant cases. They can help with divorce, child custody agreements, and a couple more. Call them, tell them about your situation. They may not help you, but they may, so it's worth a shot. So, the terminology that is good to know before we continue is the check-in and check-out form. So in previous classes, we've talked about what a check-in and check-out form is, which is the document that you fill out for your apartment's, what is the word I'm trying to say? Condition. So before you move any of your furniture in, I strongly suggest you do a walkthrough, you look for any imperfections, and then after a couple days, you're going to take a shower, you're going to do some dishes, plug things in, then you're really going to get to know your rental unit, and then you can make more additions to that checklist if need be. And then I also want to remind you that you have 7 days to get that back in after you move in. So deductions are essentially just anything that is taken out of your security deposit, which you should be getting a receipt or a deduction letter of where your security deposit is going. And then intent to vacate, which is telling your landlord, I'm moving out at the end of my lease. If it is a month-to-month agreement, which is the next one, which is each month, is a lease, and they can be suspended after 14 days before the next month. But if you inform your landlord that you're intending to vacate, they cannot take your security deposit unless there's further damage or other things. Then we have rental agreement, which essentially is just your lease. It's what you sign, or I guess what you verbalize, because a verbal agreement in Wisconsin is legal. Then a security deposit, which is the landlord's insurance, essentially, of making sure that when you move out, if you do have damage, that they have some money to put towards fixing that. Then tenancy is essentially where you are living. You are a tenant. Normal wear and tear. So what I don't like about normal wear and tear is there's not a cut and dry definition. So my normal wear and tear is going to look different because I have a large German Shepherd and a baby on the way soon, versus some of you who may have 6 kids, or 2 teenagers, versus somebody else who is retired by themselves. Wear and tear is going to look different. So I did some digging, and essentially wear and tear is allowing the landlord to take about 2.5 to 3 hours to prep for the next tenant to come in, including patching up picture holes and painting. So if the prep goes longer than that, then normal wear and tear is probably not occurring. So also, if there's any stains, holes, anything crazy going on, that goes beyond normal wear and tear. But if you have carpet, you're walking on your carpet, you're going to get the normal track marks. You're going to get certain things are just going to need replacing after a while, which is normal wear and tear. So security deposit. So your rental history can affect how much you pay in security deposit. So there's no cap on landlords asking you how much. But I suggest if you are having a hard time finding a place and they are saying that the security deposit is $500, offer $800 or $1,000. Money talks. If you can save up. There are resources to help you pay for security deposit if you need it as well. And some things that people don't know about security deposits are, once the lease ends, you should get your money in hand or postmarked within 21 days of that lease ending. And if there's anything removed from your security deposit, you should get a deduction letter, which I have an example that can be passed out to you. So if you pause a video, it's a white paper. It's white. It'll be passed around, and then you can take a look. Hopefully you have seen this before. If not, I strongly suggest when you move out to ask for it. You should know where your money is going. Now that doesn't mean that they can't charge whatever they want, because they can. They can charge $50 to change a light bulb, but as long as you know where your money is going. Also, you must inform the landlord that you are ending the lease, or they can keep your security deposit as last month's rent if you're not open with them. So that is what the security deposit deduction letter looks like. And like I said, it's an insurance policy for the landlord. They can keep your security deposit for damage, waste or neglect of the property, late payments of rent, unpaid utility bills. So make sure those things are in order before you move out. Otherwise, you will probably not see your security deposit. All right, so if you could go to page 2 in your packet, and it is labeled rental agreement checklist. So you will be passed out a lease agreement, which I will have you look through and fill in this sheet. So who can live in the apartment? What is the protocol for bugs and rodents? So pause this video, and then when you're done, we can go over the answers. All right, welcome back. Let's go over the answers. So who can live in the apartment? It should be Nicholas and Nicole. That is page 1, and you can also find that on page 9 as well. How long does the rental agreement last? So it is 10 months from October 1st of 2017 to August 31st of 2018. And that is found on page 1 as well. Who is responsible for maintenance and repairs? That is page 11 under number 25. It is essentially up to the tenant to make the repairs or pay for them. When can the landlord enter the apartment? 12-hour written notice minimum to make repairs or share prospective tenants or purchasers, or for purposes authorized by the law. And that was found on page 6 under number 21, right to enter. Which utilities are the renter's responsibility? This was found on page 1, which is water, sewer, and electricity. When is rent due? The first of every month, which is under page 1 under rent. Who is responsible for making sure the smoke detectors and carbon monoxide detectors work in the apartment? It is the leaseor and the leasee, which is page 10, number 12. What is the protocol for bugs and rodents? That is found on page 10 under number 21, extermination costs. The tenant is responsible for paying for any bug or rodent extermination. And last but not least, what happens if the lease agreement is broken? The tenant must give a written warning at least 60 days prior to vacating. A $500 break fee will be given, and the tenant is responsible for paying rent until the unit is rented out or at the end of the lease. And that was found on page 9 under number 12, vacating prior to end the lease. All right. So now we can talk about the general eviction process. I hope most of you do not have any back history with eviction, but I'm sure there is at least one person. So I'm going to go over this with you. You have this chart on page 3 in your packet, but I'm going to break it down for you because it can be confusing. So it first starts with a 5-day notice, which is given to the tenant by the landlord for a violation of the lease agreement. And so you have two options here. Either you can fix the violation and move out, or you do nothing. So if you fix it, that is called curing. So you fix the problem. So if you got a 5-day notice from not paying rent, you have 5 days to pay your rent and all is well. Let's say you ignore this 5-day notice. Then what happens is you get a 14-day notice. That is given from the landlord to the tenant. This 14-day notice is a written notice to give the tenant 14 days to move out. You may not cure this at this point. There's no fixing it. Either you move out and you're still not evicted, or you can stay and further the eviction process. However, a 14-day notice can only be given within a 12-month period of a 5-day notice. So what does that mean? Let's say May 2019, you forgot to pay your rent. You cured it. Within the 5 days, you paid your rent. And in September 2020, you goofed up again. You did not pay your rent. They cannot give you a 14-day notice because it surpassed a 12-month period. But if you make a mistake less than 12 months, then they can just give you straight a 14-day notice and skip the 5-day notice. So let's say you get this 14-day notice and you don't move out. Then what happens? Well, you get a summons and complaint. So what that is a paper filed through the court that gives a return date on this. And when you get the summons and complaint, you have two options. You can move out and you are still not evicted, or you can show up to this return date on the summons and complaint. So let's say you show up to the return date that is listed on the summons and complaint. And essentially what it does is it still gives you time to move out. You are still not evicted. Or when you show up to this return date, you are given an eviction trial date. So the eviction trial, this is where you, the tenant, can bring any paperwork, receipts, documentation that you have to prove that you should not be getting evicted, as well as the landlord can bring their documentation as well, and a trial will be held, and it can go in either favor. If I'm going to backtrack a smidge, if you do not show up to that first return date that we talked about, it will automatically go in the landlord's favor. So if you are communicating and showing up to your dates, you are still not evicted. So let's say it went in your favor and you are not evicted. Well, what happens? You obviously do not have to move out, but the landlord or the property manager cannot deny you of renewing your lease at the end of your lease agreement because of this. Now, that doesn't mean that they're going to pick another reason why they don't want to, but legally, they cannot hold this accountable or hold this against you. And they should not treat you any differently because you went to trial with this landlord. Let's say that it went in the favor of the landlord. Then what happens? Then a writ of restitution is issued. So what that is a piece of paper from the court that is served by the sheriff's department to the tenant. So that means you can stay in the apartment or a rental property until you get the knock on the door from the sheriff's department. And once that happens, you will be moving out. There's no extending your stay. There's no sweet talking. You will be removed. So my advice to you is, although it is a very stressful situation, just be compliant because the sheriff's department can determine how long you have. If you are belligerent, you're yelling, you're screaming, they can say you have 10 minutes, get as much as you can out. Or if you are sweet as pie, they might give you a couple hours, depending on the sheriff, depending on their work schedule that day. But that's my advice to you. So hopefully the eviction process being broken down is helps you understand it. And I know a lot of people, they think that they've gotten evicted because they got a 14-day notice and they moved out. But you are not evicted until you are served the writ of restitution. So, what some things are that I want to talk about are a 20-day 28-day lease, which is a month to month. So if you go into a month to month lease, which I strongly do not recommend, but if it does happen, the landlord only has to give you 14 days for you to move out. So just think of where that would bring you. It might bring you back to square one, which we hope that does not happen. So try to get a full year's lease. What a self-help eviction is an illegal way of trying to remove a tenant from the property. So this would mean the landlord is cutting off power, locking you out of your apartment, removing your items, shutting off your water, all of these things to get you removed or for you to move out before the eviction trial or the restitution is given. This is illegal. They cannot do this. I've had several residents who have had this done to them, and they thought it was legal because it is their property. That is not legal. They cannot do that. What joint and several liability is essentially a very fancy way of saying if your roommate leaves, you're responsible for paying for all of the rent, utilities. So keep that in mind. All right, before we continue, I would like you to go to page 4 in your packet and do the moving on quiz. It's true or false. When you are done, we will play the video and I will go over the answers. All right, so number 1 is false. Number 2 is true. Number 3 is false. Number 4 is false. Number 5 is false. Number 6 is true. Number 7 is true. Number 8 is true. Number 9 is true. And number 10 is false. Okay, so your next page is number 5, and what that is just all of the terminology that we went over today. So what a 5-day notice is, the eviction trial, summons and complaint. So that is just a resource for you. If you don't have any questions, then you are free to go. And if you do have questions, just feel free to reach out to your case manager, and I'm sure that they can assist you. All right, see you later.